Hi, everyone. Harry here to talk about the latest in Judge Zinnis's chambers. She's the one who's presiding over the Abrego Garcia case. And she is playing it pretty smart, but it's maddening because the administration continues to basically flout, ignore, misconstrue, and prevaricate about her orders. So recall, she said, I want this information. I want you to report to me every day what you've done to try to facilitate and effectuate, I'm going back to the beginning here, the return of Abrego Garcia, whom the United States admits was mistakenly sent. A little aside there, the person who said it, because it was true, and others have said it too, Pam Bondi then fired after a 15-year career for not vigorously for not lying to the judge, for saying the truth of it. Anyway, that goes up, recall, through the Fourth Circuit and the fantastic opinion by conservative icon J. Harvey Wilkinson, making it clear this is really, really basic stuff. And everything is on the line for the democracy. And it then goes to the Supreme Court, which affirms unanimously this basic idea that the U.S. has to facilitate the freeing from custody of Abrego Garcia. And it then goes back. It does tell her also, Judge Zinnis, clarify what you mean by effectuate, and be sure to have due regard for the foreign policy interests of the executive. The executive, of course, made a big deal about that, but it's just boilerplate, and you can see it in the word effectuate. They couldn't, if the administration came in with a plausible reason that effectuating his return would have terrible foreign policy consequences, that might be one thing. But facilitating his release, doing something, as she did in her last order, shouldn't be a problem. And in particular, their stance that they tried to have of we're not going to tell you anything, even to give you the information that you want, would trench on our foreign policy considerations, is just A, hogwash under the law, B, completely contradicts the Supreme Court. Okay, so it goes back down to her, and she orders a very compressed period of depositions. I want no playing around with, telling me about what Bukele and Trump said in the Oval Office. We want sworn testimony. I want declarations. I want documents. I want a few depositions if necessary. I'm ordering this to happen in 2 weeks. They go off and start. And now, yesterday with the order is when we first find out about what's going on. And basically what's going on, the U.S. is continuing to play all kinds of games and interposing all kinds of bogus objections and trying to, get out of it. Zinnis is playing it smart, and you can think about other judges who have been in this setting. She knows that she's got a lot of power here because the Supreme Court backs her. But if she does anything too rash, if she says, okay, that's it, I want the president here personally, or whatever, that could create some daylight between her and the court. So she goes through, and I'll itemize a little bit myself, all the ways in which they are acting in bad faith. They're not even trying just to say sometimes, oh, does it mean that? We thought it meant this. It's worse. They're really basically ignoring orders, completely mischaracterizing what the Supreme Court said, really complete, just sort of, gutter level for litigants. This is what you see, the worst kind of in a federal court, the lowest level of, ambulance chaser kinds of litigants doing, except this is the Department of Justice for the United States government. So it's stunning. Okay, but she basically goes through and said, I deny that, I deny that, I deny that. This is another bogus objection. Here's one. Okay, plaintiffs clarify a little. So she gives, a little bit of ground. I deny that, and says, United States, I want answers by today. That is, she wrote it yesterday, today, Wednesday at 6:00. And, they'll freak out or maybe try to seek emergency relief. But we're just in discovery now. And she's just backing up the orders that she already gave and that they've ignored. And by the way, that they've known about for weeks. They also played it sort of fast and loose in not beginning to comply even before this, when it waiting on, sort of rolling the dice and losing at the Supreme Court level. So she's now, notably, all the newspaper reports say, one quotes it was a bloodbath, and others say she was really tough on them. But actually, the opinion is, which is what everyone's reporting on, somewhat restrained, and in particular, it doesn't hold them yet in contempt. So the big sort of hammer that it drops at the end is what I just said. Give me this information and give it now. And otherwise, it's a pretty much, just go down the line and say why their objections are totally full of it. Let me give you some of them now. So they keep talking. They say again and again, like they think it's clever, that this question or interrogatory that they're asking, the plaintiffs are asking them, is based on a false premise. And that false premise is that the United States can or has been ordered to facilitate Abrego Garcia's release from custody in El Salvador. Unfortunately for them, that's precisely what they've been ordered to do. That's the facilitate. They've got to facilitate, and it's got to be the release from custody. They purposely misconstrued it before, saying, if El Salvador delivers him to our shores, then we can, but that's all we can do. They literally are saying it's a false premise and then proceed just to say what they've been ordered to do. So she overrules all of those and gives it this is bad faith. She says it's a bad faith refusal to comply with their obligations. That's heavy stuff. It's, it sounds a little courtly in court speak, but bad faith, and especially the United States government, it's big. Then there's just the U.S., in some kind of confused sort of doggerel way, throws up privilege objections. Oh, we need, this is work product, executive privilege. Oh, deliberative process privilege, but completely unwarranted. And when you claim privilege, you're saying, it's got a real cost. We don't have to provide evidence that the rules otherwise say we have to provide. You have to serve up your basis for saying that to a judge. If you say attorney-client privilege, you have to show a judge that this communication was for the purpose of getting legal advice from, it only went to such and such a person. There are prerequisites. They've done none of that, but just sort of slapped the label and inconsistent labels on it at that. So she says, sorry, good try, and goes through some of the different kinds that they do. They're saying we won't give you, they're drawing their own arbitrary line, any discovery if it predates when the court first got the case. But that's bogus also, because the court needs to know, the Supreme Court has said, she needs to be able to determine the right way to facilitate his release. So the discovery includes, when did you pick him up? How'd you pick him up? What kind of warning? That's stuff that's really necessary. They're saying, it was before April 4th. So what? It just, doesn't mean, they can't on their own say discovery. You have to give any material that's relevant, and it's clearly relevant. So. All right, there are more of grudging or partial or just absent compliance with specific questions. I could go, this interrogatory, like 7 or 8 different interrogatories, which she said, again and again and again, except for this one, as I mentioned, that, okay, why don't you clarify your request, plaintiffs? She's denying them all. I mean, more than denying them, she's really taking the administration to task for continuing to play games. And it is continuing to play games. they're gambling, I guess, that if it goes back up, the Supreme Court will sort of flinch or say, yeah, I know we said do it, but you're being a little too tough on them. It's just hard to say and see why and how the Supreme Court would, having staked the claim and supported her, would not back her. She's doing exactly what she's been told to do. Get discovery, get it in short order. And this, the expedition of it really matters. We got a guy potentially rotting away in jail. And as she has said, and others have repeated, that's irreparable injury every day. So the bottom, it's harsh on the one hand, but it gives her room to keep going. So when she does go to contempt, there's a record that, she gave him every chance. And she tells him, get your act together and get it together now. And that's the state of play. Discovery, the parties are supposed to cooperate, do it themselves. So we had just a few of these things, and now they've come back to the court, and the court says, totally, you're really jerking around the process, jerking around me, and more than jerking around Abrego Garcia, who is in jail based on a mistake, and you're continually trying to get out of remedying it. So strong opinion, stronger one to come, though, if they keep horsing around, which I think we can expect they will. And the question is, how careful need she be? How, one step at a time need she step in order to safeguard what really matters here? That is the backing of the Court of Appeal and the Supreme Court if it comes to it. So that's the reason for a harsh tone, but not so harsh remedy for this first stage. And we're still in this sort of 2-week discovery process. I expect them to continue to be purposely non-responsive, and her to come out with a warning for contempt and then contempt, and, a whole nother emergency screaming up to the Court of Appeals and the Supreme Court by the administration, which you gotta hope at this point it would be such a reversal, will back up Zinnes. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.